So the definition of confinement is a little bit broader in the Restatement Third than the Restatement Second. So we've included more examples of confinements that might not have explicitly been considered confinement under the Restatement Second.
What constitutes a confinement is an actor intending to limit a person's ability to leave a particular space. A classic example would be locking a person in a room, or a police officer insisting that a person go into the patrol car and drive to the police station to answer questions. So it's basically non-consensually but intentionally confining a person. It is an intentional tort, so if a security guard negligently fails to check whether there's anyone remaining in the store when they leave the store at the end of the night, and somebody's left locked in the bathroom, that would not be an intentional confinement. It's a confinement, but it would be negligently caused, and there would not be any intentional tort liability for it.
One area in which we've expanded the definition of confinement is confinement by assertion of legal authority. Confinement by assertion of legal authority in the Restatement Second was fairly narrowly applied, at least in the case law, to false arrest type situations or wrongful arrest situations. There are cases, however, and our current draft reflects this, where assertion of legal authority can be by a teacher to a student, or to a non-student who's visiting a school, or an airplane employee, or a security officer, or really anyone who's sort of vested with the mantle of the law or asserts that they're vested with the mantle of the law to confine someone. Under the Restatement Second, if one had a belief that the police officer was not privileged to stop one. Let's take a stop and frisk scenario. I'm a lawyer, I'm walking down the street. A police officer stops me, and let's say I know that the police officer has no reasonable suspicion, no probable cause to stop me and frisk me. Under the Restatement Second, my knowledge that the police officer has no right would vitiate my claim for false imprisonment. That's no longer the case under our draft. Even if I know that they don't have a right, if I feel that I have a duty to obey, simply as a citizen, or because I'm worried that they might use force, or because I'm worried that they might then charge me with resisting arrest, then it's okay. I still have the right to claim false imprisonment, despite my knowledge that they have no legal right to stop me. So that's an interesting difference in our drafts.